Today, our next video lecturer is Helen Adetunji. Please welcome her.
Good day, esteemed viewers. I'm Helen Adetunji, a 400 level law student of the University of Ibadan and an undergraduate intern at HARLEM Solicitors. Today, I'll be taking you on a short yet insightful journey into the topic Lawful Interception of Communication in Nigeria. Before I proceed, I would like to give the definition of communication, interception, lawful interception of communication in Nigeria, and unlawful interception of communication. What is communication? According to the Oxford Dictionary, communication is the exchange of information by writing, speaking, or through other medium. Communication covers the broad range of phone calls, text messages, emails, voice notes, and video calls. What is interception? Interception is the receiving of electronic transmission before it reaches the intended recipient. It also means the monitoring and the recording of private communication of individuals and organizations. What is lawful interception of communication? Lawful interception of communication is a legally authorized process whereby a communication service provider gives authorized officials access to the information of individuals and organizations. On the other hand, unlawful interception of communication is the unauthorized interception activity into the communication of individuals and organizations. The lawful interception of communication overlaps with the right to privacy of individuals. In view of this, I would like to talk briefly on the right to privacy of individuals in Nigeria and the restrictions to it. Section 37 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, hereinafter referred to as the 1999 Constitution, provides that the right to privacy of people, their homes, correspondence, telephone conversations, and telegraphic information are protected. This is, however, subjected to the provision of Section 45, subsection 1 of the 1999 Constitution, which restricts this right as long as it is in the interest of defense, public health, public safety, public morality, and in the protection of the freedom and rights of other individuals. This may seem like an infringement of the right to privacy. However, the argument that there should be absolute protection of the right to privacy is flawed because from time to time, the government may need access to these communications in order to ensure that the safety of the public is guaranteed. This is especially true for a country like Nigeria, where kidnapping, indiscriminate killings, and terrorism is spiking at an unprecedented rate. One thing to note about Section 45, subsection 1 of the 1999 Constitution is that this restriction to the right to privacy of individuals can only be done when it is reasonably justifiable in a democratic society. In order to ensure that the lawful interception of communication is done in the rightful way in Nigeria, we have several laws guiding interception. In this discourse, I'm going to be talking about 3 of such laws. The first law I'll be considering is the Lawful Interception of Communications Regulation 2019. This regulation, hereinafter referred to as the 2019 regulation, is formulated by the Nigerian Communications Commission by virtue of the provision of Section 70 and 147 of the Nigerian Communications Act. This provision in Regulation 5 criminalizes the unlawful interception of communication in Nigeria. This regulation also provides ways through which lawful interception of communications can be conducted. In this regulation, I will be considering 2 ways whereby lawful communication and interception can be conducted. The first one is lawful interception without warrant, and the other one is lawful interception with warrant. Lawful interception without warrant is provided for in Regulation 8 of the 2019 regulation. It provides that lawful interception of communication can be carried out in 3 different ways. Firstly, if there is consent by one of the parties to the communication and there is incontrovertible proof to this effect. Secondly, if the person carrying out this interception is a party to the communication and has reasonable belief that there is threat to human health and safety. And finally, if in the course of that business it is required to record and monitor such communication. Moving on, Regulation 7, Sub-Regulation 3 provides for the interception of communication with warrant. This regulation provides that a judge will grant warrant only in 5 circumstances in Nigeria for interception of communication. Firstly, if it is for the purpose of the protection of national security. Secondly, if it's for the purpose of preventing and investigating crimes. Thirdly, if it is for the purpose of preventing and safeguarding the economic well-being of Nigerians. Fourthly, if it is for the interest of public emergency. And lastly, if it is to effect an international mutual assistance agreement that Nigeria is a part of. Moving on, this regulation in Regulation 11 specializes that internet service providers and licensees must provide communication services that can be monitored and intercepted. This regulation further provides for the punishment for non-compliance in Regulation 16. Moving on, I'll be talking about the Cyber Crimes Prohibition Prevention (ETC) Act of 2015, hereinafter referred to as the Cyber Crimes Act. This act also criminalizes the act of unlawful interception of communication in Nigeria, and this is provided under Section 12, subsection 1 of the Act. It also provides a punishment of not less than 5 million naira for a person who unlawfully intercepts communication in Nigeria. Under this act, there are two spectrums of interception. We have the narrower regime, and we have the broader regime. The narrower regime is provided for in Section 39 of the Cyber Crimes Act. It provides that a court can give authorization for the order of interception to receive an electronic communication for the purpose of a criminal investigation or proceeding. This interception is based on the authority of the court. On the other hand, the broader regime of interception is provided for in Section 38 of the same Act. This provides that an internet service provider can provide the communications of an individual for the period of 2 years and retain it at the approval of a relevant body or a law enforcement agency. It also provides that this communication can be released on request to such relevant body at any time it may be requested. This particular provision does not give room for the sanction of the courts, which can also give rights for misuse. In a country like Nigeria that is democratic, this fraction of the law cannot be said to be reasonably justifiable in a democratic society, as provided for by Section 45, subsection 1 of the 1999 Constitution. Finally, I'll be considering the Terrorism Prevention Amendment Act of 2013. Just like these other laws, this Terrorism Prevention Amendment Act 2013, hereinafter referred to as the Terrorism Act, also criminalizes the unlawful interception of communication in Nigeria. In Section 29 of this Act, it is provided that the Attorney General of the Federation can, with the approval of the Coordinator of National Security, approve and can apply for a warrant of interception under 3 circumstances. First one, if it is for the Prevention of Terrorism Act. Secondly, if it is for the enhancement of detection of Terrorism Act. And finally, for the prosecution of offenders. This law also specifies the time limit for each warrant of interception that is received by the Attorney General of the Federation. Now, you might be wondering, why are there so many laws guiding the lawful interception of communication in Nigeria? Well, this is to make up for any lacuna of the law that may want to be permitted by any of the laws, like the Cyber Crimes Prevention Act, that provides a broader spectrum of lawful interception of communication in Nigeria. We have come to the end of this lecture. If you need more informative videos like this, you can subscribe to our YouTube channel. You can also go to our website www.harlemsolicitors.com for more insightful information on telecommunication law. Thank you.